All right, we're on the record in docket 22-01695. It's people of the state of Michigan versus Bree Scott. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Good morning, Your Honor. John Abbott representing Bree Scott. We both appear by video today.
And ma'am, you are Bree Scott?
Yes, Your Honor, I'm here.
All right, can you hear me okay with that? Okay. This is the time set for a preliminary examination. Mr. Witzy, how are we proceeding today?
Your Honor, I believe defense is seeking an adjournment. Defense counsel has some medical issues. There was some delay in discovery. I believe that's been sorted out. So I believe those two reasons are good cause that people do not object.
Mr. Abbott, is that your understanding?
It is, Your Honor. I've got COVID. I can't come to the courthouse. And it looks like my client is also testing positive for COVID. So we're better off not there today. As regards to the discovery, I know that we've sent a new appearance, and apparently that's been received, and they've sent police reports or video, but I still haven't received it yet. So hopefully we'll get that sorted out very soon and be prepared whenever the court schedules our preliminary exam. Thank you.
All right, and the I see for the record, Mr. Abbott, that your client has not waived her 21-day. Does she plan on waiving that today?
Yes, although I
All
haven't
right.
discussed it with her, but yes.
Right, but I'm not that this isn't good cause, but I mean, it'd be simpler if she waives it today, and you're correct. We don't want you here if you have COVID or your client. So may I inquire of your client about her the waiver of her 21-day?
Yes, Your Honor.
All right, Ms. Scott, you understand that you, under Michigan law, you have a right to a preliminary examination within 21 days of your arraignment?
Yes, Your Honor.
And a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime was committed and by probable cause evidence of the identity of the person who committed that crime. That's a right you have to have that hearing within 21 days. If you waive your right today, you'll still have that hearing. You'll just have it outside of that 21 days. Do you understand that, ma'am?
Yes, Your Honor.
So is it your intent today to waive your right to a prelim within 21 days? Of course, you're not waiving your right to a complete prelim.
Yes, Your Honor.
All right, I find the waiver of the 21-day rule to be knowing, voluntarily, and intelligently made. Any question on that, Mr. Witzy?
No, Your Honor.
And let me get a new date for you. So it'll be, the new date will be August 18th at 8:30.
Thank you.
Thank you, Mr. Abbott. Ms. Scott, if you have any questions about that date or any questions about what this proceeding on August 18th at 8:30, please keep in contact with your attorney, Mr. Abbott, okay?
Thank you, Your Honor.
All right, Mr. Abbott and Ms. Scott, I hope you guys feel better, okay?
Thank you.
All right, thank you. That's all for the record in 22-01695. How are you, Mr. Austin?
I'm well, Your Honor. Thank you. And how's the court today?
We're good, good. Better than Mr. Abbott and Miss Scott.
Yeah, apparently.
Yeah. So we're on the record in docket 22-01824. That's people of the state of Michigan versus John Scott Schuster. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Schuster. He's present, standing to my right.
And sir, you are John Schuster? All right. Mr. Whiskey, how are we proceeding today?
It's my understanding that the defendant is seeking an adjournment. He plans to hire counsel, is my understanding. He's seeking some time to do that. I leave that in the court's discretion. The people will be ready and prepared to go today.
Mr. Austin, is that your understanding?
Yes, Your Honor. Mr. Schuster is working on retaining counsel. He'd be requesting a brief adjournment to make that happen. He believes 2 to 3 weeks would be sufficient. He has been advised that he is entitled to have this particular hearing within 21 days of his arraignment that's set to occur today. By making this request, that hearing will be set or will occur outside of that time frame. And he understands that he is not waiving or giving up his right to have the hearing. He just won't have it as quickly as the law says he's entitled to.
Thank you. May I inquire of your client concerning the waiver of the 21-day rule?
Yes, you may, Your Honor.
Mr. Schuster, you pursuant to what's been spoken, do you have any questions about adjourning this matter so you can retain counsel? And you understand that you have a right to a preliminary examination within 21 days of arraignment. And a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that the crime was committed, and then the identity of the person who committed the crime. You understand that?
Yes, sir.
If you waive that right today, you won't be waiving your right to having an actual preliminary examination. You'll only be waiving your right to have that prelim within 21 days. Do you understand that? Is it your intent today to waive your right to a preliminary examination within 21 days? All right. I find your waiver to be knowing, voluntarily, and intelligently made. Mr. Witsi, any questions about the waiver on the 21-day?
No, Your Honor.
Mr. Austin?
No, Your Honor.
All
Thank you.
right. So I will adjourn this matter so that defendant can seek new counsel. And we'll probably need, since the adjournment of 21, I'd say at least 2 weeks, if not 2 to 3 weeks.
August 18th.
Okay, August 18th at 9 a.m. will be your new date. If you retain new counsel, that date should go to the new counsels right away so they know that they're due here on a prelim for August 18th at 9 a.m. And then I'm sure they can talk to Mr. Austin concerning any questions about the case, all right? Anything else for the record, Mr. Witsi?
No, Your Honor.
Anything, Mr. Austin?
Nothing further on behalf of Mr. Schuster. Thank you.
All right, thank you, sir. We'll see you on August 18th at 9 a.m., okay? All right, that's all for the record, docket 22-01824. Ready? All right, let's go on the record on docket 22-00846. People of the state of Michigan versus Tyrone Anderson. Tyron Anderson. Will the parties please introduce themselves for the record?
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Kimberly Stout on behalf of Mr. Anderson, and I apologize for being a few minutes late. The construction is always a surprise to me. I don't know why.
I think you're fine, Miss Anderson.
It's just the Michigan.
Miss Stout. Mr. And you are Tyrone Anderson?
Yes.
Okay. This is the time set for preliminary examination today. I will indicate, I know that we've adjourned this a couple of times for various COVID ailments on both sides. What are we doing today, Mr. Pfeiffer?
Your Honor, will the people locate an officer who still works for the LPD, who is at the scene and could provide testimony for bind over? He's not here today, and the people are unable to proceed. As a result, we'll be nollying this case.
No objection.
And if I may approach with the people sign nolly.
Sure. So this is a dismissal without prejudice, without objection, I assume, correct?
Correct, Your Honor. I would ask for dismissal with prejudice in that the evidence, as the court may recall, is going to all be hearsay, which would supposedly be admissible pursuant to Omley, but I would disagree.
I understand the case. I'll indicate, and I've said before, I'm not a fan of the case, but it is what we have for preliminary examination. It's not an issue of this case because we do have a dismissal. May I inquire your client of the dismissal, ma'am?
Of
I'm
course.
just going to explain to him. Mr. Anderson, that today the case is dismissed. It's dismissed without prejudice, which means that the prosecutor could bring the case back if they want to. I would say it's unlikely at this point, given the circumstances, but that is an option they have. But for today's purposes, the case is dismissed. All right, sir. Okay. Is there anything else for the record, Mr. Pfeiffer?
Only that I do not believe there are any plans to reissue this one.
All right. Ms. Stout, any comment or anything else for the record?
No, but thank you, Your Honor.
All right, thank
Nice
you.
to be in your courtroom.
Thank you, Ms. Stout. Mr. Anderson, good luck to you, okay?
Thank you, Your Honor.
Thank you, Mr. Pfeiffer.
Your
All
Honor.
right. Let's go on the record on docket 22-01345. People of the state of Michigan versus Jennifer L. Cressman. Will the parties please introduce themselves for the record?
Jake Witty on behalf of the people.
Aaron Robinson, Assistant Public Defender on behalf of Ms. Cressman.
And ma'am, you are Jennifer L. Cressman? All right. Mr. Witsi, this is the time set for preliminary examination. How are we proceeding today?
Your Honor, we're seeking an adjournment. The purpose is to have Ms. Pressman screened for a mental health court solution that would encompass this and another misdemeanor file.
This is the adjournment's being requested by both parties, right?
Correct.
Yes, Your Honor.
And Ms. Robinson, that's your understanding of the request for both parties is to seek an adjournment for mental health screening?
It is, Your Honor.
And does your client plan to waive her 21-day right?
She is.
All right. So may I inquire your client
You
concerning
may.
her 21-day right? So Ms. Cressman, you have a right, under Michigan law, you have a right to a preliminary examination within 21 days of your date of arraignment. You understand that?
Yes, sir.
And the preliminary examination is a probable cause hearing, which would indicate that the people are proving by probable cause evidence that a crime's been committed and by probable cause evidence, the identity of the person who committed that crime. That's your right to have within 21 days in district court. You understand that, ma'am?
Yes.
If you waive your right today, you won't be waiving your right to a preliminary examination. You can still have that. You're just waiving your right to a prelim within 21 days so you can get the screening that both parties are requesting.
Yes, sir.
All right, and you understand that, and your intent today is to waive your right to a preliminary examination within 21 days.
Yes, sir.
Any questions on that, Mr. Witsi?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor.
So I find the waiver of the 21-day rule to be knowing, voluntarily, and intelligently made. We're going to set this out for maybe 4 weeks, 3 to 4 weeks.
Yes, at least 3. She is lodged in Clinton County, so I know that it may be a little more difficult for the mental health court professionals to
Alright,
get out and see her.
Let's
So
do at least start at 3 and see. So
August 18th.
August 18th. 18th at 9, and then if there's a problem, just let us know and we can put out.
absolutely, we'll do your thank you.
So August 18th at 9 a.m., Ms. Cressman, you'll be back in this court, hopefully after the screening. If you have any questions, please keep in contact with your attorney, Ms. Robinson, okay?
I will, sir.
All right. Anything else for the record, Mr. Witsi?
No, Your Honor.
Ms. Robinson?
No, Your Honor, all set.
All right, that's all for the record, docket 22-01345.
Thank you.
We're on the record. Okay, we're on the record docket 22-01220. This is people of the state of Michigan versus Mary Lou Riemenschneider. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, to pick on behalf of the defendant.
And you are Mary Lou Riemenschneider. All right. It's my understanding that there's going to be a request by both parties for an adjournment today. Is that
Yes, Your
fair? Okay. Let's see. The request for adjournment is the request for adjournment is granted. We'll do 2 weeks of 2-week adjournment.
August 11.
So August 11th
8:30, Judge.
at 8:30. At 8:30. Write some notes. All right, so a couple things here that have been brought to my attention, but one is that, so we're adjourning this matter till August 11th at 2022 at 8:30. If you have any questions about that,
No.
please contact Mr. Feigelson or whoever's representing you from the Public Defender's Office, all right? Second is we got an initial indication, the pretrial services indicated that you were in violation of your GPS, all right? And now they've indicated that you're back in compliance with GPS, all right?
Yeah.
But we want to avoid that at all costs, right?
Yes.
Yeah, because as soon as they contact us, then we violate your bond and then you're back in front of me.
Right.
And then we're trying to figure out what to do with it and we don't want to do that. And we still have a prelim to go through. So we want to make sure you're in compliance with your bond conditions. My understanding is you might have to have the GPS tether checked.
I'm supposed, oh, can I speak? I'm sorry.
You sure
I'm
can.
supposed to, as soon as I leave here, I'm supposed to go there to have it checked and turned back on. They had it to where I owed $126. They didn't register me as the indigent for my SSI.
Okay.
So they took those away. Then I made every payment. Those, they just figured were back payments from the late payments because I'm supposed to be paid by Thursday at 6, but don't be able to get the money until Friday. So they occurred.
Just so you understand, this is priority because
Yes,
it
sir.
becomes a priority because we're adjourning the matter and we don't want you to end up in violation of bond on a GPS after you and I've had this discussion, okay?
No, sir.
All right. So the adjournment's granted. Keep in contact with your attorney. That's August 11th at 8:30. Anything else for the record, Mr. Witzy?
No, Your Honor.
Anything, Mr. Feigelson?
Just quickly, Your Honor, I just want to make sure that the GPS tether from the email I read that I got this morning, it is turned on. They need to inspect it to make sure it works.
Correct. It has to be inspected to make sure it's working correctly.
She's aware of that and she's gonna
Oh,
have.
no,
it
that
right
makes me
now.
feel a lot better because I thought it was off. So
Okay.
the inspection sounds a lot better.
All right. All right. Just keep it as a priority and we don't have to worry about
I'm
it,
going
okay?
straight there after.
All right. Anything else for the record, Mr.
No, Your
Feigelson?
Honor, thank you.
All right. Thank you.
Thank you.
on the record in docket 22-01847. People of the state of Michigan versus Sandra Trice. Will the parties please introduce themselves for the record?
Jake,
Denise Trice.
Okay, go ahead, Mr. Wisty.
Jake Wisty on behalf of the people.
Thank you, Your Honor. Good morning, Jared Austin, appearing on behalf of Sandra Trice. She's present, standing to my right.
And ma'am, you are Sandra Trice? All right. This is the time set for preliminary examination today. Mr. Witsi, how are we proceeding?
Your Honor, the people will be filing a nole for the reason that our witness didn't appear. So we cannot proceed to prove this beyond a probable cause to continue. We request that the nole be granted without prejudice.
Okay, any objection to that, Mr. Austin?
No objection, Your Honor, and understanding that the dismissal is without prejudice as a matter of law.
And Mr. Austin, can I just indicate to Ms. Trice what that means?
Yes, sir.
All right. So Ms. Trice, at this time, the witnesses have failed to appear, so the case is being dismissed against you, okay? It's being dismissed without prejudice, which means that the people could bring their case back if they choose to, but for today's purposes, the case is dismissed. Do you understand that, ma'am? All right. And I'll sign that nollie to make sure. Anything else? You can bring that. Thank you, Mr. Witsi. Anything else for the record, Mr. Witsi?
No, Your Honor.
Okay. Anything, Mr. Austin?
Nothing further, Your Honor. Thank you.
All right. So Ms. Trice, in this case, it's dismissed without prejudice today, okay? All right, thank you.
All right, thank you, Judge.
And if you want to copy
Do I need to run over there?
Not yet,
Okay,
hopefully.
yeah,
It's in the other courtroom.
door's fully closed too.
So let's give it a shot and we'll see. So we're on the record in docket 22-01852 and 21-01010. My understanding, we're going to call them both at the same time.
Yes, Your
All
Honor.
right. And then I'll just make certain that we have the count separated, since we have the same witnesses. So this is People versus John Gates. I'll start with the 22 file since it's listed. But either one, parties will introduce themselves for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Robert Palmer of the Public Defender's Office appearing on behalf of Mr. John Gates, the gentleman who's seated to my right.
And sir, you are John Gates?
Yes, Your Honor.
Okay. This is the time set for preliminary examination on both files. How are we proceeding, Mr. Pfeiffer?
Your Honor, the people are prepared to proceed today. An offer was presented to defense counsel this morning, provided to the defendant. The defendant has turned down that offer. So the people will be proceeding with preliminary examination on both files.
All right. Is that your understanding, Mr. Palmer?
That is an accurate statement, Your Honor. I did discuss the matter. Well, Mr. Gates and I have discussed the matter several times in preparation for today. But he and I did discuss the matter this morning while he was downstairs in lockup. I did review the offer. It's my understanding he continues to desire his preliminary examination. So we're prepared to move forward at this time.
All right. So the people may call their first witness.
Thank you.
Just before we do that, I would just ask, to the extent that Mr. Pfeiffer intends to call other witnesses, I would ask that they be sequestered.
Absolutely.
I think there may be some law enforcement officers, and I'm not sure which order he has intends
Yes,
to call.
but they are sequestered at this time, Your Honor.
All right.
The only other person in the courtroom is my intern,
Okay.
who's not a witness.
So I think we're good.
Yeah,
All
no,
right.
no objection to that.
All right. So Mr. Pfeiffer, you can call your first witness.
People would call Stephanie Kraft.
Ms. Kraft, I'm going to have you stand right in front of me and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under the penalty of perjury? Okay. You can sit right here. Ma'am, I'm going to have you speak up as loudly as you can because we have another courtroom with another proceeding going on. And we're also try to talk right into that mic, all right, because we're recording. And then what file are the first facts going to be on?
I'm going to try and take this chronologically, so I'll be starting with 21-01.
All right.
010.
All right, I just, for the record, I want to make sure. So the beginning testimony will be in regards to file 21-01010.
There's likely naturally to be some bleed in, and there shouldn't be an evidentiary issue since under 27B, evidence of domestic violence crimes can come in for each case as each of them would.
010. All right, you may proceed as to file 21-01010. And then when we get to the substantive testimony of the second file, we can make a record then.
Understood. Morning. Could you please state and spell your name for the record?
Stephanie, Stephanie, middle of Ann, ANN, last Craft, CRAFT.
Thank you. And while I ask you these questions, if at any moment you need to take a pause, please feel free to take it. And if I ask you something and you just simply don't know the answer or you don't remember, please feel free to give that answer. Those are perfectly valid answers to give. All we want is your honest recollection. So I'd like to first ask you, do you know a John Gates? How do you know him?
We met a couple of years ago via social media.
And were you in a dating relationship?
Yes.
And at any point, did you live together?
No.
And would you be able to recognize him if you saw him again?
Yeah.
Do you see him in the courtroom today?
Yeah.
Could you please identify something about him that distinguishes him from the other individuals in the courtroom?
Mask on and blue jumpsuit.
Thank you. If the record can reflect that she's identified the defendant in this matter.
Any objection?
Not for the purposes of exams.
Okay, without objection, the witnesses identified the defendant.
Now, I'd like to take you back to the night of April 13th, morning April 14th of 2021. Did you have contact with police officers that day?
Yeah.
Officer Josh Byers.
Stop.
And was that in regards to an assault?
An altercation that was, yeah.
And was the other individual in that altercation John Gates?
Yes.
And did this take place on the roads around Jolly and Cedar Court and around Jolly Road?
Yes.
And is that in Lansing?
Yeah.
Is that in Ingham County to your knowledge? And around what time of night on the 13th did this start? To your best recollection?
I did 16 hours at work, so he picked me up 11 o'clock at night, probably 11:15 or so. I think, it was 2 years ago.
And
Getting off work.
And that's why, like I said before, if there's something you just have difficulty remembering, because it was a while ago, please feel free to give that as an answer.
Okay.
Now, at that time, were you living at 4914 Star Avenue,
Yes,
Lansing?
yes.
So you said he picked you up from work around 11:30 that night. What can you tell me happened during this altercation?
I was agitated. I was actually on a medication at the time called Atipex. It took me, it was 6 months of hell for me. It was during COVID. We own and operated out foster care homes. I was working 16-hour shifts. When he picked me up, it was just a verbal argument. He made
At any
a smart.
point, did it become physical?
Yes, he called my family crackers, and I said, after your dead family or something to that effect, and he smacked me.
And where did he snap?
Okay.
In the face. So what happened after he smacked you?
I became belligerent, tried to jump out of the car, and I spit at him, and
You say try to jump out of the car. What's
my
that?
daughter was in the back seat. I was just livid that he smacked me in front of my daughter, and at that point, it was,
Was the car moving at the moment?
yes,
At some point, did the car come to a stop?
yes.
And at that time, did you try and get out of the car?
I was trying to jump out for probably a mile.
But once it was stopped?
Once it was stopped, yes, I got out of the car.
And at any point, were you forced back into the car?
Forced back into the car? No.
Did you go back into the car?
My daughter was in the car. My concern was her.
At any point, did he grab you by your hair?
It was a mutual, I don't recall that.
Do you remember if he told police that day that he had grabbed you by your hair, and dragged you back to the car?
I don't recall.
Did John have a firearm on him
No.
that day?
He did not. I told the police he did. I told the police several times. Can I elaborate on that or no?
Please.
We were rolling. I was concerned about my daughter after the smack. I had texted the police and I had texted them and they weren't finding me. I thought they could pinpoint our location. We were driving around for a second. I thought they could find us and just, at that point, I was looking for them to intervene, somebody to intervene. I was out of control. He was upset. We have a 7-year-old and that.
Your 7-year-old, that was your daughter?
Yes,
Is he the father of that
No.
child? No. Okay, so just your child.
yes.
Now you said that you were texting 911. At some point, did
Texting
you?
911, they did not respond quick enough for me.
At some point, did you call them?
I don't recall calling. I just remember taking my daughter's phone and texting while I was in the back seat. But I remember saying he had a gun, so I thought that would speed up them coming to me.
So you got back in the car,
Yes,
and then did he drive you to 4914 Star?
we went home, yes.
Did he pull you into that house?
Pull me in? No, I jumped out of the car and it was out of control again. We were both, he was trying to get me to calm down and come inside and I was just,
So you were not trying to go inside.
no, at that point, we had a physical confrontation when I got out of the car. And we were going back and forth. I got the worst end of it, obviously my eye. And I was livid again at that point.
Judge, could we approach very briefly?
Sure. My concern. My concern is she needs a lawyer. Yeah, I think I need to advise her of that now. It may or may not. All right, so. Ma'am, after consultation with counsel, and I don't know if we have another counsel present, but there seems to be some contradiction in some of your statements, and before you on the record indicate that your statements, uh, uh, before you speak more, you should probably talk to a lawyer, okay? You should probably talk to a lawyer to advise you of your rights in regards to making any incriminating statements under oath. Or does that make sense to you? There's statements you made previously and there's statements you've made now, and there may be some discrepancy. And I don't want you to continue making statements under oath that may possibly be used against you. So that we probably, so it's your opinion. If it's up to you if you want to go forward, but it's the advice of, after consultation with counsel, it's the advice that you talk to a lawyer first before you make any further statements concerning this matter. You understand that? So the question now becomes, do we have a lawyer present?
No, Your Honor.
Judge, I guess I could, the answer is I doubt it. I could step into the hallway and see, but I think potentially that would, anybody from my office would be a conflict.
Yeah, it could possibly be.
I think so.
someone
And the only way I'm thinking, and I'm reluctant to go forward without her talking to somebody that is separate from this case and would be separate from, and your office is somewhat conflicted out. I don't know if you want to look in the hallway to see if there's anybody.
I did see Jeff Rothstein earlier.
Yeah,
I could go ask him.
Yeah, he is in the preliminary, and he would suffice. But he was in the prelim, and Judge Simmons prelim, I think.
Okay,
I'm not sure, but if you would do that, or
I will.
both of you,
I'm happy to step across
Yeah.
the hall, Judge, or
Just to
Mr. Pfeiffer and
see-
I can both do it together.
yeah, just to
and
see.
if that can't happen, because sometimes the people are frankly prepared to finish their questioning of Ms. Kraft and proceed with the officers and ask for bind over at the end of the day.
All right, but we've already started. Let's see if there's anybody out there that can, and then I'm reluctant to go forward with the witness, but if there's somebody who can advise her, and then we can take additional testimony.
Thank you.
Rob, you able to go look for him?
Yeah.
Well, so let's go back on the record in docket 21-01010. And for the record, we're just attending the defendant to make sure that he's in a comfortable state. At this point in time, we were unable to find an independent counsel to advise with rights. I think it's necessary under the circumstances. So what I'm going to do is I'm going to have Ms. Kraft step down from the stand so we don't have any further testimony from her. I think she's got to talk to a lawyer before there's any further testimony. But I'm going to have you leave the courtroom, but stay in the vicinity. All right. You're not allowed to leave the building until we figure out what we're going to do with you in regards to representation. All right. And it's really it's really my decision at this point. And I'm just more comfortable with you getting an attorney to advise you of your rights and to talk to you somewhat. It probably would have to be a conflict counsel, I would think.
I would think so, Judge.
Yes.
I saw him like 45 minutes ago. It's Jackie Moss. Is the one who's across the hall.
Not familiar.
He's a good guy. He works for Mike Nichols. But
Right.
Yeah, and he doesn't do conflict stuff. I think Rothstein, because we have, usually when we have this situation, Judge, we assign an attorney who's already on our conflict
Right.
roster to that client
Right.
which Rothstein is, which is why I felt comfortable with it. But that's Jackie Moss, who works for Nichols firm, and I don't believe he's on our conflict.
Right.
Would that be
And
necessary? Must at least be able to provide preliminary advice.
I-
Person to.
I'm not going to make Mr. Moss do it, but I want Mr. Rothstein would be the natural alternative.
Right.
But until we arrange that somehow, I think we're put in a position where the witness can't testify till she talks to either some counsel or conflict counsel.
I agree.
That doesn't mean that you can't continue with other proofs
Thank you.
in this regard. We can cross-examine officers, etc. But I think in regards to this witness,
I believe that'd be correct.
this witness has to talk to a lawyer. So, ma'am, I'm going to have you step down from the stand. You'll have to leave the courtroom, but stay outside the courtroom. And in the meantime, I think for your best interest, we need for you to talk to a lawyer. Okay. All right. And then, so we will still go on the record in 21-01010. Mr. Palmer, we were making sure your client was in a good state for the exam. So your client's able to proceed right now?
Yeah, if I could have just.
Okay, sure.
He's okay to go.
All right. So the staff made sure that he was breathing all right and of that nature. I just want to make sure that he's okay to go.
And I appreciate that.
Proceed. Mr. Pfeiffer, with the understanding we've taken a break with the first witness, Ms. Kraft, you may call your second witness.
The people will call Officer Josh Byers, and is going to grab him right now.
Okay.
Sees the officer on 21-01010. We continue with that file.
All right. All right, officer, if you'll stand right up here and raise your right hand. You're Officer Josh Byers.
Yes, sir.
Can you spell that for my court reporter?
BYERS.
Okay. Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, you may be seated, sir. I'd have to ask you to speak up as loud as you can because we're recording, okay?
Okay.
There's also a prelim going on in the opposing courtroom, so do your best. You may proceed.
Good morning.
Good morning.
Mr. Byers, where are you currently employed?
With the Lansing Police Department,
How long have you been employed there?
2 years.
2 years. And what is your role there? What's your position?
I'm a police officer.
Officer Byers, were you working in that capacity on night of April 13th, morning of April 14th, 2021?
Yes,
And on that date, did you make contact with a Stephanie Kraft?
I did.
make contact at 4914 Star Avenue.
Yes,
And did you speak with her?
I did.
First of all, did you observe any injuries to Ms. Kraft?
I did.
And did you take photos of those injuries?
Yes.
Your Honor, if I could approach the officer looking marked as plaintiffs, proposed exhibits 1, 2, 3, and 6.
1, 2, 3, and 6. Yes.
Officer Byers, do you recognize the photos I just handed to you? And are those photos that accurately depict what Ms. Kraft looked like on that night, that morning when you spoke with her?
Yes.
And could you please briefly describe what is in each photograph for the record?
There a particular order you want me to go?
Numerical order. The numbers should be on the yellow stickers.
In plaintiff's exhibit 1, this is a picture of the right side of Miss Kraft's face that is meant to show her swollen right eye.
Thank you.
In plaintiff's exhibit 2, it's a picture of Miss Kraft's face showing the bloody nose that she had. Plaintiff's exhibit 3 is a generalized picture of the upper half of Miss Kraft's body. And in plaintiff's exhibit 6 is depicting Miss Kraft's hands and the defense marks and broken nails that she had.
Thank you. And you took those photographs?
I did.
And that was inside the ambulance?
Correct.
People would move to admit people's proposed exhibits 1, 2, 3, and 6.
Any objection?
I don't believe I have any basis to make an objection for the purposes of.
All right. So exhibits 1, 2, 3, and 6 are admitted into evidence.
And the people would move to admit them or present them to the board this time.
Granted.
Publish. Sorry, I could not think of the right word.
Granted, sir. Thank you.
Did you also look at her car? Was there?
I did.
And did you find blood inside the vehicle?
Yes.
I'd like to approach the witness with marks as people's proposed exhibits 4, and 5.
Okay. You may. Any objection to that?
I have no objection, Judge. He's showed him to me.
All right.
And officer, are these the photos you took inside the car showing the blood inside the vehicle?
Yes.
And those are an accurate depiction of what it looked like that night?
Yes.
Thank you. People seek to admit those exhibits and to publish them to the court.
Motion to admit people's exhibit 4 and 5. Any objection?
Again, no objection for the exam, Judge.
Exhibits 4 and 5 are admitted into evidence. May publish.
Thank you, Your Honor.
Thank you.
As a result of talking with Ms. Kraft, did you determine that an assault had taken place,
Yes.
a domestic assault,
Yes.
and that she was the victim of this assault?
Yes.
Did you determine that it had recently taken place?
Yes.
How recent?
Within the hour.
In the hour. Your Honor, the people would seek to move forward in introducing into evidence statements made to Officer Byers by Stephanie Kraft under MCL 768.27C. To believe all the elements have been met, in regards to it being to a law enforcement officer by a victim of domestic violence who suffered physical injury or was physically assaulted. It was close in time, and there is clear corroborating evidence as is exhibited by the exhibits published to this court.
And that would be for purposes of prelim only.
Yes, Your Honor.
Any objection?
Judge, could I have just a second?
Sure.
With regard to that.
There's some case law to that, if I remember correctly.
Judge, I understand the court will make a ruling and I will obviously comply with whatever ruling the court comes up with. I would object to those statements coming in under 27C for this reason. One of the conditions is that, let me find it here, make sure under 27C, parent 1, parent D, is that the statement was made under circumstances that would indicate the statement's trustworthiness. I'm going to submit to the court that we don't have that now, and therefore those statements are inappropriate. Would it be inappropriate to admit? The reason being is that we've now had this issue where the person from whom the statements sought to be introduced are coming has already, as we know, taken the stand and made contradictory statements under oath. So I'm not sure now how the court would then I guess, judge or make some sort of a determination on the trustworthiness of the complaining witness's statements, given that at least until the other issue regarding her potential incrimination is here. Obviously, she's unavailable at the moment, but not, I don't know what the right term would be. She's not truly unavailable. Her unavailability is caused by her own statements under oath, I guess. I'll put it that way. So I would object. I understand Mr. Pfeiffer's position, but my objection would be that these are not trustworthy statements because we've now heard from her own mouth in this court contradictory statements, and I don't know how the court is supposed to weigh those statements for the purposes of making a finding.
I might respond, Your Honor.
Mr. Pfeiffer?
First of all, her being available or unavailable has no bearing on 27C, the introduction of its evidence, or the trustworthy nature of it. Secondly, for purposes of Section 1D, circumstances relevant to the issue of trustworthiness include, but not limited to, whether it's made in contemplation of pending or anticipated litigation in which the claimant is interested, whether she has a bias or motive for fabricating the evidence, the extent of any bias or motive, and whether it's corroborated by evidence other than statements that are admissible only under this section, such as the blood in the vehicle and the injuries to her person. Your Honor, it is not whether she is trustworthy now, it's whether circumstances show that when she was speaking with this officer directly after this incident took place, it is trustworthy what she was saying to that officer. And given the fact that we have these corroborating factors that were observed solely by the officer, independent of what she told him, I believe that that clearly meets what is asked for under MCL 768.27C. It is used frequently to impeach victims who can stand to potentially either perjure themselves or simply recant. When the statute was pondered by the legislature and was argued by the legislature, that is one of the explicit reasons why they passed it. So I had to research the legislative history of this statute, and that is one of the arguments that was made in favor of it passing, not to its detriment.
I guess in follow-up, I would just say there's a question here. One of the other conditions is whether there's bias or motive for fabricating the statement. She's already admitted that she fabricated some statements. So how we determine which statements she's fabricated and which statements she has not, I don't know how the court is supposed to make that decision. The best, I would suggest to the court, the best way to do that is to hear her own testimony, not through hearsay testimony on statements that she's already admitted at least are partially true.
Thank you. But the way I read the statute is that we're looking at these statements. First of all, I won't give you my own opinion of the statute. It's a confrontation issue that's been resolved by way of legislative mandate. The trustworthiness is at the time of the incident. The bias and infliction are at the time of the incident. And everything that I've heard afterwards in regards to representation of the witness who testified is after the incident. I find that the exhibits 1 through 6 corroborate the testimony that the officer was hearing at the time of the incident. So that's trustworthy at the time of the incident. And there's no bias that can be regarded in regards to the night of, and that would be April 13th, 2021. So I will allow the statements in hearsay format to come in. The officer's here to testify pursuant to the statute indicated by counsel, which is 27.85, with the understanding that I still have to make a decision for bind over, and I'm not going to make a decision for bind over until the decision on the first witness is decided. Because the witness was called, and I don't think I can make a decision without having that witness's availability or unavailability. I look at it as unavailable right now because of privilege. comes to fruition on some level. And we got to make sure that we have some resolution of that matter. But I do believe that the statutes have been met in order for this officer to testify. So the objection's overruled, and the officer, you may continue your testimony in regards to the direct examination.
Thank you, Your Honor. Officer Byers, did Stephanie Kraft tell you the name of the person who assaulted her?
She did.
And what was that name?
John Gates.
Did she identify the relationship that they had?
She said they had been dating.
Was he there at the scene when you spoke with her?
No.
So he had already left by then.
Yes.
And you're speaking with her at her residence on 4914 Star Avenue?
Correct.
Did she tell you if the assault took place there or somewhere else, or at least started somewhere else?
It started somewhere else.
And was that around Jolly and Cedar Court?
Yes, it was around that area, but it also sounded like maybe also around Cedar and Norfolk.
And those are within Ingham County?
Yes.
So how did she tell you this started?
They were having an argument because Mr. Gates had called her family a bunch of crackers. As the argument continued, she stated that she told Mr. Gates, "Fuck your family," at which point he punched her in the nose.
In the nose?
Correct.
And you saw evidence of an injury to her nose?
Yes.
Is that what we saw in the photographs?
Yes.
So what happened after he punched her in the nose? What'd she say happened next?
She said that she opened the car door, and that's when he pulled over into the Jolly Cedar Court, Jolly area. She exited the vehicle, and he chased after her, grabbing her by her hair, dragging her back to the car while punching her in the head repeatedly.
So she was trying to get away and he physically brought her back into the vehicle.
He was dragging her that direction, and she was still fighting him. So she said he pulled a gun from his waistband, hit her in the head with the gun, and then pointed it at her. At which point she felt scared for her life and got back into the car long.
At some point, did he tell her that he was going to kill her?
Yes. When he pointed the gun at her.
Because she got back into the vehicle.
Yes.
So what did she tell you happened next as they're driving away from this alley?
They were driving away. He was headed back to the address on Star. He had apparently saw some police cars, so he started taking back streets. She had called 911 and left an open line. During the drive back, he was attempting to reach in the back seat and hit her. And then at some point during the drive, he took the phone.
And then did he end that call to 911?
I'm not clear as to whether that call was already ended or if he ended it.
So at some point did they arrive at 4914 Star?
Yes.
And what did she say happened once they got there?
When they got there, she stated Mr. Gates pushed her daughter into the house and threatened to hurt her if she didn't listen to him.
Threatened to hurt the daughter?
Correct.
The 7-year-old?
Yes, then 5.
At that point, 5. And so what did Stephanie tell you she did?
She started walking away from him southbound on Star.
So away from the house?
Correct.
And what did she say happened next?
That he grabbed her by the hair and dragged her into the house.
Did he still have the gun on him, according to what she told you?
Yes.
Did she try and escape out of the house again?
She did. She said that she went into her daughter's room and opened up a window, so that Mr. Gates approached her, put the gun to her head, and said, "Bitch, count your days."
And did that stop her from leaving the residence?
Yes.
Did she say if she had somehow been able to get a message to 911?
I believe at some point she was able to. it was after when Mr. Gates had calmed down and started apologizing for his actions and asked if he could stay at the residence.
By the time you got there, he was no longer at the residence, correct?
Correct.
And he was asking to stay there.
Yes.
Did she give you any identifying information about Mr. Gates that you can remember at this time?
She stated he was a black male, approximately 6'3" all the time,
Did she say where he was from?
California.
And she have any concerns about him being from California?
She's believed that he was on parole in California.
Did you attempt to locate Mr. Gates?
We did.
And were you or your fellow officers successful?
No.
Now, I'd like to approach the officer with what's been marked as People's Exhibit 7, Proposed Exhibit 7.
May approach.
Now, Officer Byers, can you give the front page of that a quick read and tell me what you were looking at?
It is a court record from the Superior Court of California in the County of Los Angeles.
Can you please flip to the next page? You see a judgment of sentence? Or record of sentence there?
I do.
And does it say, can you see the name of the individual at the top of it?
I do.
And what is that name?
John Levon Gates,
And does it say what charges he was sentenced to?
robbery second degree, and assault with a firearm on a person.
Does it say those are felonies?
Judge, I'm gonna object to relevance here. I'm not exactly sure. I think that's a self-authenticating document and he can enter it for the purposes of felony firearm, but I'm not sure what the purpose of introducing it through this witness is.
Response,
If that's the case, then I will just seek to admit it as an exhibit now.
as, yeah, I think it can be admitted or stipulated of the prior felony without getting into the basis of the prior felonies.
Judge, quite frankly, I don't want to stipulate to it, but I think he can certainly admit it under the court rules. I believe it's a self-authenticating document, so I don't think I have any basis to object to his entry. I don't know what the purpose of introducing it through an officer who doesn't have a connection.
So you move to admit?
I would, Your Honor.
Okay, motion to admit People's Exhibit, is it 7?
Yes.
All right, as to a self-authenticating document of judgment of sentence, any objection to that?
I don't have any
Oh,
basis for that.
Then seek to publish it to the court. at this
You
time.
may.
And we saw some photographs that were admitted. What injuries did you personally observe on Miss Craft?
She had a swollen right eye and a bloody nose, and then the broken fingernails.
And why were the broken fingernails significant to you?
It showed the defense. She attempted to defend herself.
Is that a common defensive wound you've been trained to look for?
Yes.
And you suspect you found blood inside the vehicle?
Correct.
That was the vehicle that Mr. Gates had been driving Miss Craft in?
Yes.
And I know only 2 pictures were made, but do you find blood in other parts of the vehicle as well?
Yes.
Can you generally say what areas of the vehicle blood was found in?
In the front part of the car, both driver and passenger side.
I want to go back just very briefly. And you remember Ms. Kraft said Mr. Gates pulled the gun from?
So where he pulled the gun from?
Yes,
She says waistband.
his waistband. Thank you. You're at this time, people have no further questions for Officer Byers.
Any cross?
Thank you, Your Honor. Good morning, sir. Um, So I have some questions for you. First of all, so you responded, you were dispatched to the address on Star Avenue, is that right?
Yes, sir.
And you were dispatched by 911?
Correct.
So, and you had an opportunity to talk to Ms. Kraft that day, correct?
Yes.
When you talked to Ms. Kraft, did you ask her about the gun?
I asked her what kind of gun it was.
What kind of gun? Was she able to identify what kind of gun it was?
She told me it was a small black handgun.
Okay. And she said that my client had produced the firearm from her pants, or excuse me, from his pants. Is that right?
His waistband.
From his waistband. All right. Did you ever search the home or ask anything about what happened to the gun when Mr. Gates left?
I did not search the home. I don't recall if she told me if he took the gun with him or not.
Okay. I guess okay, that's fair. You never personally saw the firearm, is that right?
That's correct.
And so you never collected any firearms or ammunition or anything of that nature for evidence, correct?
That's correct.
Now, obviously, at least the testimony here today is that part of this assault occurred in the vehicle, also correct?
Yes.
Did you personally, or do you know if that vehicle was then also searched in addition to the photographs taken?
I don't believe I searched it.
Okay. To be fair, there was no firearm found in the vehicle. Is that right?
That's correct.
Do you know, I know you took some photographs of the blood inside the vehicle. Do you know if any further testing was ever done? In other words, I don't know what the right term for it would, but would the crime scene team or anything like that come out and take any kind of swabs or testing to determine whose blood that was? Well, first of all, whether it was blood, and second of all, who pulled it.
It was not for the process.
It was not for the process. All right. And you observed some injuries to Miss Kraft's, I think, eye and her nose. Is that right?
Yes.
And then the other injuries that you observed, you photographed, would be the broken fingernails, correct?
Yes.
Did you observe any other injuries?
No.
Did she require, or did she refuse medical treatment?
Yes, that's correct. She refused to go to the hospital with the paramedics.
The photographs of her nails, I probably wouldn't know myself, but are those fake nails or real nails?
I'm not sure.
Okay. The nails themselves were broken, is that right?
Yes.
And I think your testimony, correct me if I'm wrong here, I think your testimony originally was that those are defensive wounds, is that right?
That would be typical of defensive wounds.
Is it possible that those wounds, at least to her hand, could also be caused by if she was the aggressor?
It is possible.
It's possible. So, for example, she could have broken a nail clawing at his face or something, correct?
Sure.
And you did not ever, as far as you personally, never saw Mr. Gates there that evening, right?
Right.
And so you don't know whether he had any injuries or if he was even there, other than her statement, right?
I don't personally know. I believe she did tell me that he might have had an injury, but I don't specifically recall what that was. I would have to see.
Fair. Now, Miss Kraft, did she ever say anything to you about, back up. So she said that there was some sort of an argument that was what started this incident. Is that right?
Yes.
All right. And that argument occurred inside the vehicle, correct?
Correct.
And her statement to you was that he struck her. My client struck her because he had made some sort of derogatory term towards towards her family. Is that right?
That she had made a comment about his family.
She made a comment about his family, and
Right.
and then he responded by striking her.
Yes.
Do you know, or did she ever say anything about assaulting him first? In other words, did she ever say anything or tell you that she spit in his face first, that she struck him in any way, anything like that?
Not that I recall.
Not the truth. Did she ever say whether she physically fought with Mr. Gates at any point that evening?
I believe she said she defended herself. She didn't specify exactly what it was other than she was trying to get away.
She was trying to get away. Okay. So then they arrived back at the house, and at which point they head inside to the address on Star. Is that right?
Yes.
As far as what Ms. Kraft reported, there were 3 of them in the vehicle then, correct? That would be Ms. Kraft, Mr. Gates, and Ms. Kraft's daughter.
Yes.
Was Ms. Kraft's daughter, and I'm not going to say the name, but was Ms. Kraft's daughter present at the time you interviewed Ms. Kraft?
Yes.
So Ms. Kraft's daughter would have been, and she's a juvenile, correct?
Yes.
And she would have been a witness to this incident. Is that right?
Yes.
Was she interviewed at all about her? And I'm not asking what she said, but if she did say anything, but was she interviewed at all about her experience or her recollection of events?
No.
And this is not accusatory, but why was she not interviewed?
Due to her age.
Then there's some incident, a sort of, I guess, a second incident inside the home, correct?
Yes.
All right. And at that point, my client allegedly still has a gun on him, correct?
Yes.
And she being Stephanie, tries to escape, at which point Stephanie told you that my client dragged her back inside by the hair. Is that right?
No, that was prior to that.
Okay.
When she tried to escape through her daughter's bedroom window, she said that he pointed the gun at her head and said to counter days.
Okay. So I got you. All right. So at some point, as they're going inside the house, then it is that Mr. Gates is alleged to have yanked her by her hair.
Yes.
And so he, according to her statement, he drags her all the way into the house by the hair.
Yes.
There were, and you indicated in your report, well, first of all, you authored a report about this incident. Is that right? And after your interviews with Ms. Kraft, you canvassed the area regarding security cameras that may or may not have found video of the incident. Is that right?
Yes.
And so it looks like there's 5 of them. There's the MSU, FCU, the Lansing Urgent Care, Walgreens, U-Haul, and Astera Credit Union. Is that right?
Yes.
Do you know whether any of those businesses actually had any kind of video footage that would have shown the incident?
I do.
Do you know? Do you know whether any LPD officers or anyone, I guess for that matter, ever went out and followed up to see if there were additional video cameras that would have shown the incident?
I don't.
Thank you, Your Honor. I have no further questions this one.
Redirect.
What was the emotional state of the victim's daughter?
She seemed like she was acting like I would assume was a normal 5-year-old.
And how about the victim?
She was crying, scared, and upset.
You said in direct examination that once they were in the house, after he pointed the gun or had and told her to count her days, that he asked to stay there.
Yes.
Thank you. Your Honor, at this time, we'll no further questions for this officer.
May this witness be excused?
You may, Your Honor.
Without objection, the witness is excused.
Yeah, with no objection.
So do the people have any further proofs in regard to this file 21-01010?
Your Honor, the people would call Officer Stacy Myers for purposes of identification in both files. Well, I know that Ms. Kraft has already identified him. Given what's going on, I'd like to cover my bases.
All right. So you may call Officer Myers. And that, so this testimony would be in regards to 21-01010 and 22-01852.
Frankly, it's going to be a bit of both.
Officer Myers, I'll have you come right up here. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth under the penalty of perjury?
I do.
All right. Can I have you sit here and speak as loudly as you can? And you may proceed.
Morning.
Morning,
Ms. Myers, where are you currently employed?
Lansing Police Department.
And what is your role there?
I'm a patrol officer,
Officer Myers, how long have you been employed with the Lansing Police Department?
7 years.
7 years. Were you employed in that capacity on July 13th of this year?
Yes, I was.
And on that day, did you respond to 4914 Star Avenue?
I did.
Is that in Lansing?
Yes, it is.
Is that in Ingham County?
Yes,
And were you there in regards to a call involving John Gates?
yes, sir.
Were you there with Officer Riley?
Yes,
And was contact made with a Stephanie Kraft?
yes, it was.
As a result of speaking with Ms. Kraft, were you looking for John Gates on those premises?
Yes, I was.
Did she give you a description of Mr. Gates?
Yes.
And what description did she give, to the best of your recollection?
Black male, about 30 to 45 years old.
So you canvassed that area for him?
Yes,
Did you happen to find someone matching that description?
I did.
And what can you tell me about when you found that person?
That person was in the backyard of the residence on Star, walking towards the back door.
Towards the back door of the house at 4914?
Yes.
And what did you do when you saw this person?
I yelled at him to stop, told him it was the police, stop. He continued to walk into the residence after glancing over towards me, and he did not abide by any of my verbal commands.
Do you see that individual here today?
I do.
Could you please identify where he's located? Maybe something about him differentiates him from the other people in this room?
He's wearing all blue or black with handcuffs.
Your Honor, the record reflects she has identified the defendant in this matter as the individual she located that day.
And that's the identification is for the July 13th, 2022 date in file 22-01852. Any objection to that?
For the purposes of exam today, Judge.
All right, thank you. So the witnesses identified the defendant for file 22-01852.
Did you eventually arrest that individual?
I was with the arresting officers.
And how did that arrest happen?
After he didn't comply with my verbal commands, he went inside the residence. A few minutes later, he did come back out of the residence. At that time, I was giving him more commands. He did show me his hands, and he said he was going to walk to the front of the residence, where officers actually made contact with him on the side of the residence.
As a result of this arrest, was an identification made?
Yes, it was.
And was that individual identified as John Gates?
Yes, sir.
Thank you, Your Honor. And I'd like that to the court, I would like the record to reflect identification in both files as a result of this.
All right, but I have it on the date in question. I have as July 13th, 2022. And she's identified Mr. Gates as to the person as July 13th, 2022. I don't think I make this person identify him in a date that they didn't see him, unless they're familiar with him.
I agree with that, just that this individual is John Gates.
Okay, any objection to that?
I guess I agree, I think, with the court's ruling that Certainly I have no objections to the identification for the purposes of the July 13th, 2022 incident. I don't know that she can identify him, as the court said, for the
Just to
previous
add-
incident, or go back and say that that would be the same guy that was there.
I believe I'll be able to make that link with Officer Riley.
All right, so with that understanding, the witnesses identified the defendant for the July 13th, 2022 incident.
Thank you. And at this time, the people have no further questions for Officer Myers.
Any cross-examination?
I have no cross-examination. Judge, thank
May
you.
this witness be excused?
She may.
All right, without objection, the witness is excused. Oh, and ma'am, can you provide my court officer with the spelling of your name?
Yep.
And you may call your next witness.
Thank you. All right, the people will call Officer Colleen Riley. I believe Officer Kraft's gonna help get her into the courtroom.
Okay. And Ms. Riley, that's to file 22-01852.
Correct, Your Honor.
Ms. Riley, I'd have you come up, Officer Riley. I'm gonna have you raise your right hand right here. So, and spell your first and last name for the court reporter.
My first name is Colleen, Colleen, last name is Riley.
Okay, Miss Officer Riley, do you promise to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, you can have a seat here. Speak as loudly as you can, ma'am.
Good afternoon.
Good afternoon.
Ms. Riley, where are you currently employed?
The city of Lansing,
In what capacity?
as a patrol officer.
Is that with the Lansing Police Department?
Yes, it is.
And how long have you worked in that capacity?
I've been with the city of Lansing Police Department for 3 years and on patrol for a year and a half.
Now, Officer Riley, were you working in that capacity on July 13th of this year?
Yes, it was.
And in that capacity, were you dispatched to 4914 Star Avenue?
Yes, it was.
And once you arrived there, did you make contact with Stephanie Kraft?
I did.
And what was her demeanor like?
She was upset and emotional as well as scared.
Did you observe any injuries to Ms. Kraft?
I did observe some scratches on her neck and upper chest area.
And without getting into specifically what was said, did that seem to match up with what she had tell you had happened?
Yes, it did.
And did she say that as a result of talking with her, did you determine that an assault had taken place?
Yes, it did.
You determined that assault was domestic in nature?
Yes.
And was it?
Yes, it was.
Did you determine very recently taken place?
Yes.
And as a result of that conversation, were you looking for John Gates?
Yes, it was.
Was he found at that residence?
He was.
Thank you. Your Honor, I would seek to proceed under MCL 768.27C and have Officer Riley testify to the statement Stephanie Kraft made to her on July 13th, 2022 about that assault.
Any response?
Your Honor, I would just repeat the same objections I previously made. I don't, as long as the court's clear on my objection, I don't think I need to repeat it.
Right, this is a little different. It's a different date. We haven't had any testimony concerning this date. The stronger argument is as to the witness's first response. There does seem to be any the elements of cooperative testimony, trustworthy testimony, no indication of bias or fabrication in a domestic. I believe that the statute's been met, and I'll allow the hearsay to come in
Thank you, Your Honor.
pursuant to the prelim only.
Thank you, Your Honor. Officer Riley, what did Ms. Kraft tell you had taken place?
She first stated she was involved, in her words, were a domestic incident. She then went on to say that she was strangled by the defendant.
Now, did she give you a name as to the man who strangled her?
So she had originally given dispatch his name prior to our arrival, yes.
But so talking with her, she said it was John Gates who did it.
Correct.
Now, did she tell you how this started?
Yes, she did.
And please elaborate. What did she tell you took place?
She indicated that he had several warrants out for his arrest, and she had become increasingly frustrated that he had not turned himself in as planned. She then went on to say that she returned home from a doctor's appointment and found him still at the residence, questioned him if he had taken care of making the phone calls to take care of said warrants. And when he stated no, they began to argue.
At some point, did she say she was going to call the police?
She did.
And did she make any moves to that effect?
Yes, she did. She picked up her cell phone, dialed the 9 on it, and threatened to call 911.
And what happened after that?
She stated he became upset, ran up to her, put both his hands around her neck, and squeezed, lifting her off the floor,
Literally off the ground.
off the ground. That's correct.
Did she indicate if she had any difficulty breathing or lack of consciousness?
Yes, she did. She indicated that she believed he was going to kill her.
So I want to go back to make sure I specify for the record. She indicated there was difficulty breathing.
Yes, she did.
Did she separately indicate if she had difficulty with consciousness?
She stated she did not lose consciousness, but she felt close, or something along the lines of close that she thought she may.
So some impairment.
Correct.
And that was a result of the pressure on her neck from the defendant with his hands around her neck.
That's correct.
At some point, did he stop strangling her and put her down?
Yes, he did.
Did he say something to her?
Yes. Originally, since she had threatened to call the police on him, he had done the act which I just described. When the act was finished, he stopped and stated, "Now I'll give you something to call police about," and dialed the 1 and the 1 on her phone to complete the 911 call.
And what did Ms. Kraft said she did after that?
She stated that there was some interaction between her and the dispatcher, but she was scared and limited on the information she could provide. So eventually she ran into the back room and locked herself there until police arrived. I believe it may have been a bedroom.
Thank you. So I'll make this clear. She was starting to call the police. He ran up to her, choked her, in fact, stopped her from calling police. And then once he was done, said, "Now I'll give you something to call about," and completed the dial for her.
In her words, yes.
Did she describe her relationship with John Gates?
Yes, she did.
And how did she describe that relationship?
She described the relationship as a former dating relationship of approximately 2 years. They had recently broken up. He had moved out of state, and he had recently come back and been staying with her for approximately 2 weeks. She was trying to get him out of the residence, out of for her and her daughter's safety, and that she had made arrangements for her 7-year-old to live somewhere else during the time he was there because she did not feel it was a safe environment for the child.
Did she say if there was a history of domestic violence between her and Mr. Gates?
She did. She stated there had been many domestic violence incidents between her and the accused.
Did she say if they were reported or unreported,
She said at least one were reported.
but that there were others that were unreported?
That's correct.
Did you see Mr. Gates there?
Yes, I did.
And do you see him in the courtroom today?
I did.
You supposed to identify where he's sitting. Something about him that differentiates him from the other people in the courtroom?
Yep, he's sitting at the defense table in a blue jumpsuit and a white COVID mask.
The record reflects she's referring to the defendant.
You object?
Not for the exam stage.
Okay. Without objection, the witness has identified the defendant.
Did you discover if Mr. Gates had a warrant for his arrest on that day?
Yes, I did.
And what did you do as a result of that?
I originally ran him in lien. Then I called the jail en route to inform them so they could pull the paperwork in advance. And while he was booked in on the new charges, he was also booked in on his outstanding warrant.
And when you ran him in lien, did you discover if he had a felony criminal record? To the best of your recollection.
I did not run a full CCH on him.
Officer Riley, thank you for your testimony. And at this time, the people have no further questions, Your Honor.
Any cross-examination?
Thank you, Judge. Good morning, ma'am.
Good morning.
I just have a few quick questions for you. So you had an opportunity to speak with Mr. Kraft that morning, is that right? Or that day, I'm sorry.
Ms. Kraft, yes,
And you obtained a full statement from her, correct?
that's correct.
All right. And the photographs, there are photographs showing some injuries, is that right?
That's correct.
And those are photographs that you took?
That's correct.
Now, officer, in your training experience as a police officer, have you, prior to this date or prior to this incident, had you ever responded and spoken to victims of assault by strangulation?
Yes, many times.
And had you noticed injuries on other victims?
I have.
Are the injuries that you see that you saw on Ms. Kraft on this particular day consistent with injuries that you've seen of other victims of strangulation?
Some of them were and some of them were not.
Okay, that's fair. Could you elaborate for us a little bit about what you mean by some of them were and some of them were not?
Yes. As Ms. Kraft went on to explain the domestic violence history, she went into a brief statement of recent incidents that had happened. She started showing me some old injuries and I noticed a bruise. That bruise would not be consistent with something that would be there immediately from that day's incident. So I had her clarify and she explained she believed that one had happened in the past. So that one in particular did not appear as if it had occurred from that specific incident. The others did so.
Okay. Now when an individual is strangled, and if you don't know the answer to this, please just tell me you don't know the answer. When an individual is strangled, are there usually some markings around the neck from the strangulation?
Sometimes they're present and sometimes they are not.
In this particular case, Ms. Kraft told you that my client actually grabbed her by the throat and physically lifted her off the ground. Is that right?
Correct.
Do you know, if you know, how much Ms. Kraft weighs?
I would approximately say she is maybe 225 pounds.
And so it's your understanding, at least according to Ms. Kraft, that my client lifted Ms. Kraft, her 225 pounds, off the ground, and she was then apparently hanging by her neck. Is that right?
According to her statement.
According to her statement, right. Would the injuries that you saw, the scratches to her neck, be consistent in your training with?
Your Honor, I'm gonna have to object at this point. At this point, it's almost going into expert testimony, and Officer Riley is not an expert on strangulation. She's testified that the things she saw were consistent with what she has been trained on with strangulation. But I think now going into that level of specifics requires some kind of expert designation.
Response?
Your Honor, my response is that her testimony, as I understood it at least, was that she responded to numerous strangulations during her career. I'm trying to figure out if the injuries that she saw, at least in her opinion, if the injuries she saw on Ms. Kraft's neck were consistent with the way that the injury was described or the incident itself was described to.
I see it more as the witness is being asked questions which corroborate or do not corroborate what the officer saw in regards to what was told her. So I'm going to overrule the objection. You may continue.
I can repeat the question. If you'd like.
Please do.
Yes, ma'am. My question is simply this. Your testimony is that you've responded to numerous strangulations before. Are the injuries in terms of the scratches that you noticed to her neck, are those consistent in your experience with someone who's been, a 225-pound individual who's been physically lifted off their feet and I guess therefore hanging by their neck? Or would you have expected to see more injuries?
Based on my training and my experience, the injuries that I observed were consistent with somebody who had been strangled.
What was Ms. Kraft's demeanor at the time you spoke to her?
She was upset. She expressed fear of the accused, and she was emotional.
And you indicated, I think, please correct me if I'm wrong here, you indicated that Ms. Kraft and my client had been in some sort of dating relationship. My client had actually left for California and then come back.
That was my understanding based on the descriptions, yes.
And if you know, was it, or if you asked her, was Ms. Kraft, did my client come back to stay with Ms. Kraft at Ms. Kraft's invitation?
She did not say if it was under her invitation or not.
Any further questions?
Can you redirect?
Briefly, Your Honor. You said that you talked to her about previous domestic violence incidents. You said the recent ones.
Correct.
Are we talking in the 2 weeks that he had been staying at her place?
That's correct.
And that you saw a bruise that was because of your training, not from that day, not from that incident?
That's correct.
Where is that bruise located? On her person, I mean.
Without referring to my exact photos, I want to say it was possibly in her lower chest region or her arm, but I can't say for sure.
That's all right. He also testified that as a result of your training, you know that strangulation often doesn't have injuries that present,
That's correct.
but there were injuries here.
That's correct.
Thank you. People have no further questions at this time.
May this witness be excused?
You may, Your Honor.
Yes, Your Honor.
Okay, without objection, this witness is excused.
And Your Honor, the people are prepared to arrest even without any further testimony from Ms. Kraft and seek bind over on several of the charges as well as some additional ones based on testimony.
But there's a motion for bind over on the table. However, we have a witness that is, I think we have to get some. We started the witness. There hasn't been cross-examined of the witness. The witness is read their rights, and all this is in regards to the oldest file, which is 21-01010. That being said, on that file, in that first file, we have further testimony, and we have a witness that needs counseling on some level to talk to the lawyer. It just so happens it's the same witness as to the second file, which is 22-01852. And so it's the court's inclination. I've heard there's testimony on the table to make certain that witness, I don't know if you were going to call the witness on the second file or not. I don't know if she's going to testify to both files, but whatever the plan was, we have to have an answer to the testimony. In my regards, we have to have an answer concerning whether they've been indicated their rights and everything that goes on to their testimony.
Understood.
And since we started it, I'm reluctant to finish it without having some answer on that.
I would also note that I believe all of the elements have been met without what she testified to.
There's definitely been testimony in regard to hearsay concerning each element, but I haven't heard argument yet. But I've heard a lot of testimony. The real question is, we need to resolve the issues with the witness. Mr. Palmer, any commentary on that? We'd have to delineate each count and file per file. We still have an outstanding witness who needs to be counseled. So do you have any comment?
Well, I do have some comment, Your Honor, and my comment is this. I certainly understand Mr. Pfeiffer's position with regards to the 27C, and whether I like it or not, that's the state of the law. My concern here, Judge, is that with regards to the 2021 file, at least, we have a 7-count complaint. 5 of the counts specifically involve a weapon of some sort. And we've now heard testimony from Ms. Kraft where she specifically said under oath that there was no weapon involved, and she simply said that. And so my concern is now, if we proceed under that statute, we've got this conflicting testimony, and I don't know how first of all, I never even had it. The cross-examination was started that was brought in on, or excuse me, the direct examination was started. That testimony came out on direct exam, not even as a result of the cross. I've not had an opportunity to cross-examine her. And now the bind over is being requested on, you know, I'm presumably, I can't imagine Mr. Pfeiffer is interested in dismissing all those counts, but presumably there's going to be a bind over request on those when we've had testimony that is kind of hanging out there, which seems to contradict 5 of the 7 counts. So I have concerns and objections, I guess, in terms of proceeding to a bind over without it getting that witness matter resolved in some way and affording an opportunity to cross-examine.
I agree. I guess I agree with the reluctance to hear any bind over motion when a witness has started and then needs legal assistance and there's no cross-examination as to that witness is problematic. At best is problematic, because then we certainly have a bind over in regards to the hearsay testimony, which in and of itself may stand on its own merits, but in regard to a witness taking the stand, testifying and not finishing the testimony, I certainly don't believe that on file 21-01010 we have any resolution. And because the two are linked by the same victim and same defendant, I don't believe we can go forward with a bind over motion on 22-01852 until we get the first matter resolved, which is the standing of the witness. And I want to put that on the, I want to have a counsel present to put on the record that they've indicated their rights. I think the witness, by taking the stand, and now it's being, I would either have to allow cross-examination with the understanding that she's talked to an attorney, or if she refuses, then disregard the testimony in general. And I don't want to get to that because we don't have to make those decisions right now. Mr. Pfeiffer.
I certainly understand that, Your Honor, and I hate to complicate things. I have had this type of situation happen in the past where when there is an adjournment, it doesn't reappear.
Right.
And that is why I'm just simply making the court and Mr. Palmer aware that I believe on my side, I can get bind over with just the officer's testimony, but I do not want to just kind of sweep what happened here under the rug.
Well, let's do this. I mean, we have, so the witness should, I want to have a plan when we bring the witness back in. The witness needs counsel, whether it's appointed by the public defender's office and then goes to conflict, because obviously there's going to be a conflict counsel,
Right.
or she retains on her own. But she's got to have some type of counsel explain to her the implications of her testimony. And now that she's taken and she's been legally sworn in my opinion, since this is adjourned, she's still under subpoena. So she's not at liberty to leave and come back, unless she just fails to appear.
That's what I mean.
Right.
It wouldn't be the first time someone has not obeyed a
Right.
subpoena that I have sent.
Right. So
I've had the same. Judge.
yeah, so I think we have to put it on the record with an indication that this is being adjourned for specifically to get legal representation and an explanation of all the implications of testifying in regard to this matter under oath. She should be still here. So let's put that on the record in regards to both files.
Well, first I look outside and make sure she's still here.
Okay,
She was 30 seconds.
That's good. You want me to call her back in?
yes, please. Is there any objection to me proceeding that way?
No, Judge, I have no objection to it.
It's an anomaly, but it's one that we need to take care of.
This is one of those situations, Your Honor, where I've not run into directly this issue before, and so I think we all kind of struggle to get through it the best.
So, Ms. Kraft, I'm going to have you stand right there.
Well, maybe over.
Or over here, yes. And so, and I'm gonna call the record so we know, because we have two files. We have docket 21-01010, which you started to testify on. We've also had testimony in that regards to that case. We've had testimony that you did not testify on in regards to 22-01852. until you talk to a lawyer concerning the implications of your testimony, the court's not willing to proceed. Okay, I'm simply not willing to proceed. And so you need to be apprised of all the implications that happen when you're taking the stand and testifying under oath and all the possibilities that entails. I think it's only fair to you. Okay, it's fair to know your rights in this matter. So we're adjourning both files until you can get legal representation and you can talk to a lawyer concerning, and then when we reappear in this case, we're going to have your lawyer present, all right, to explain to the court why you've chosen what to do in regards to this case, all right? So the big question you're asking is, where do I get a lawyer? Okay. And the first question I'm going to answer is, if you don't want to pay for a lawyer, okay, or you're somehow indigent, then you apply to the public defender's office. Now, Mr. Palmer works for the public defender, so they're going to refer you to a conflict counsel, somebody who's out of the realm of the public defender's office. And then you'll talk to that counsel. That counsel will be here, and that counsel will indicate to the court why you've chosen the path you're choosing. All right, whether you want, you have to know your rights to continue to testify. All right, there may be legal implications in regards to you continuing to testify. If that doesn't suffice, then you'll have to seek your own legal representation. All right, you'll have to talk to some lawyer who will tell you your rights in the matter. Okay, and I'm doing that as to both files because you're the victim in both of these files. All right, you're still under subpoena. All right, this adjournment of the matter means that I'm indicating that when we meet again, you must be present with counsel. All right, you must be present with counsel. If not, you'll be failed to appear, and then we'll go through a contempt of court proceeding. And that's where we get into real problems for you. Okay, so this is done to protect you from testifying to things that may be used against you later. Okay, this is all done in regards to protecting you and making sure you know the legal implications of testifying under oath concerning things that you may or may have not said in the past. All right, I think you should be represented by counsel, and they should explain to you some of those implications. Do you understand that, ma'am?
Yeah.
Okay. It's rarely done, but in my experience, but in this indication, some of the things you said on the stand could be construed to be used against you. And therefore, you should get legal representation to explain that. All right. So I'm going to adjourn both these files, 21-01010 and 22-01852. And let's get a new date for testimony. I don't think we need it can be, we're well within the 21-day rule. As I see it, July 14th was the arraignment date.
I mean, we're on day 14, so it would have to be only 1 week.
Yeah, but we've started the hearing already.
Yeah,
So-
I mean, the 21-day rule actually doesn't even apply anymore.
Right, because we already started the hearing. So I would say the soonest date that's amenable to everybody's schedule.
I will make sure that either me or someone from my unit is available to cover it, so don't worry about my schedule.
All right.
Excuse me, we have obviously that day is packed, that is your soonest available day.
That's next Friday.
Mhm.
Let's
I
do,
don't think that's any different in time to council.
right, that's my concern,
I don't
is
know
to
how
get,
long it takes to go through resolution.
is to-
or council.
yeah, to make sure that you have counsel is the important part here. What's the next available date?
August 11th.
So we'll make it adjourn to August 11th. What time?
Let's say 8:30.
8:30. At 8:30. And Ma'am, we're gonna give you to start with. Since the court is one of the reasons for the adjournment is the court's not willing to go forward without you talking to counsel. So Mr. Palmer represents Mr. Sanders. I'm gonna give you the number to the public defender's office to start with. Nathaniel Field. That's the start of the public defender. If there's a reason why they can't represent you, then you're going to have to seek representation, okay? For the limited purpose of making sure you understand your rights in the case. Do you have any questions for me?
No.
Okay. You understand what's going on.
I do, but I'm telling the truth, so it's
Right.
like, okay.
Well,
I
I
called the
understand
court,
that.
Now I tell the truth, and
I-
now I have counsel, great.
Well,
No,
well,
I'm gonna be charged with a crime. I'm, my
Yeah,
mind is-
I fully understand that, and it makes complete sense to me. But what really makes sense to me is a lawyer explaining all the implications.
I just spoke with an attorney about this,
Well-
and I said, do I need an attorney? He said, absolutely not.
Well, now you do.
Thank
Now you do, and now whatever attorney you have, it needs to be present.
Thank you.
Because they're gonna make a statement on your behalf, explaining to the court why there's an indication and why you have an understanding that anything you say may be problematic for you, okay? So ma'am, I'll see you on August 11th at 8:30 with counsel, okay? Anything else? So you can, so we're all set. Yep, you're all set. Yep. Anything else for the record in docket 21-01010 or 22-01852? Mr. Pfeiffer,
Not from the people, Your Honor.
anything, Mr. Palmer?
First of all, I'll just say, Your Honor, I will make Mr. Watson available, Keith Watson, our
Sure.
new interim chief. I will make him aware of the issue and that we've obviously got a very limited time, so I'll try to speed that through.
All right,
The other thing, Your Honor, I don't know whether the court would even entertain this, but my client has asked, given the adjournment, my client has asked me to address the bond.
you may address Bob, sir.
Thank you, Your Honor. My client is currently held on some significant bonds. I certainly acknowledge that these are serious charges. And I also acknowledge right up front that he has a criminal history. Nonetheless, I guess, credibility of some of these has at least started to be called into question today. He is being held, obviously, on a bond that he is unable to afford. I understand that there's nothing illegal in and of itself about that. My client indicates that he is not a flight risk. I will note he was, at least according to testimony we even heard today, he was in California, came back. I certainly believe that he would continue to show up. I would ask that the court reduce bond to a more reasonable amount that my client may have some ability to afford.
Mr. Pfeiffer, specifically on bond.
He was first locked up, made 41 calls to the victim's number. She never answered, but he said that his name was John, and he kept saying things like, help me, please help me, God help me. Then after that, he was talking with all of his other people in California and Nevada and debating whether or not to call the victim again, now that his name is actually attached, and to try and get her help on the matter. And it took me sending all of that to Mr. Palmer talking to him, for him to say that that was not a good idea. He's tried to reach out to the victim already, and I will note those little recorded messages of help me, those do get through to the victim even when they don't accept the call. Additionally, in these messages to his family and friends, he is saying how he never would have come to Michigan if he knew that he was going to be locked up and facing these charges, and that Michigan, because of its hearsay rules, is an entrapment state, and that as soon as he gets out, he will never step foot in Michigan again. He's facing very serious charges. When he came back to Michigan, he committed more charges against the same victim. He tried contacting her, and it literally took his attorney telling him that I am listening to the calls to get him to understand that he cannot continue to contact the victim in an attempt to interfere with justice. He's also talked about how he will flee. I'd ask that the bond be kept where it is.
Thank you, counsel. In relation to bond, I've heard testimony, concerning this matter. I think the most indicative of the testimony was not only a prior criminal history and the fact that the defendant has left the state and come back, and the fact that through hearsay testimony, that there were various assaultive crimes made on both files, and an indication that this is serious. I'm going to leave bond exactly where it is. So I'm denying the motion for Mr. Palmer. This case is set for almost as immediate as the court can set it for August 11th at 8:30. The court's already started the examination process. And so the court is comfortable denying bond at this time in regards to the reduction. Anything else for the record, Mr. Pfeiffer?
Not for the people, Your Honor.
Anything, Mr. Palmer?
Not from the defense.
All right. That's all on the record for today. On the file, we'll see everybody back on August 11th.